Bunction's case has dragged on for a long time, as we mentioned, 32 years. Joining us now, KHOU 11 legal analyst Carmen Roe. And Carmen, why did it take so long for this execution to take place?
So, Lynn, like any death penalty case, it goes through a long legal battle after death is assessed. But this case is unique because the law in Texas changed after Buntion was sentenced to death. And that law change required juries to consider mitigation evidence before assessing a death sentence. And in this case, there was no question that Buntion's childhood was traumatic and marked by abuse.
Buntion's attorneys argued as of late that he was no longer a threat to society, partly because of his age. The courts didn't see it that way. Have you ever heard that argument before?
No, Lynn, I haven't. And neither has the Fifth Circuit, who made clear that, one, there's no legal basis for this claim. Two, it was untimely and it should have been raised in front of the jury who assessed death. And finally, dealing with his future dangerousness, they said it's not a certainty, it's a probability, one that was weighed by a jury. And ultimately, they made the determination that he was a future danger in this society, and so they gave him the death penalty as a result.
You talked about these death penalty cases sometimes dragging on in the courts, and in fact, an appeals court vacated his death penalty in 2009. Do you know what the reasoning was for that?
Yeah, so it was because of this law change. So in 2009, a jury convicted him and a jury assessed the death penalty, but they didn't consider that mitigation evidence dealing with his childhood and whatnot. And so in 2012, he was then presented to another jury that found him guilty. And that second jury, after considering all the mitigation evidence, again assessed the death penalty in this case.
And so were his lawyers, Buntion's lawyers, it sounds like they had come to the end of the road by appealing to the Supreme Court. That's the last stop.
Yeah, and he had two different juries here in Houston that convicted him, two different juries that assessed death. And so this is what happens in a lot of death penalty cases. The lawyers do everything they can to save an individual from the ultimate execution point. And that's what happened in this case. They made some really creative arguments here for a gentleman that is very, very far along in age, as you said, the oldest individual on death row. But ultimately, there needed to be a legal basis to stop this execution. And the Fifth Circuit and the United States Supreme Court did not find one.
Carmen, what happened in this case in 1990 echoes an argument we are hearing today about people being either on parole or out on bond. Buntion had a criminal record, and he'd been out on parole, I believe, for just a few weeks when he killed Officer Irby. And it raises the question again about whether or not people with criminal histories can be allowed back out on the street. I mean, this is something we're arguing about now, and that was the occasion back then. Your thoughts?
You know, Lynn, I could be wrong, but I'm pretty sure that Buntion's prior criminal history wasn't violent in nature. And so I don't know that it was really predictable or foreseeable that this would occur. This is a horrible offense. And, there's no question that the facts here are not in his favor regarding any self-defense issues. But, bond is something that people should be entitled to in certain cases. Certainly in this county, what we're seeing is a lot of bonds being set in violent cases, in capital murder cases. And I think everybody on both sides of the bar agrees that that's unusual and probably not appropriate in many of these cases, given the violent nature of the allegations that's before these judges.
And so here we are tonight, the death of Carl Wayne Buntion. 32 years. In your time as a lawyer, do you recall when somebody's been on death row this long?
Never. I mean, generally, I know the average that you gave was 11 years. I mean, generally, prior to 1990, I think most individuals sat on death row for about 20 years, but 30 years is a really long time. And there's other cases that were also retried because of this change in the law in Texas. And those individuals did not stay on death row as long as Buntion. And so this case is really unusual because we see this elderly gentleman who doesn't look like a future danger, who looks like someone who we could send home, but that's just not the way that the law works in Texas as we deal with the death penalty after a jury has assessed that death is appropriate in the case for all of the reasons that they're charged in the jury charge.
KHOU 11 legal analyst Carmen Roe, as always, thank you for your insight.